What are the points that are marshaled before the appellate authority? Everything connected with the inquiry from A to Z can be taken up in the appeal, right from the infirmities in the charge sheet, violations of principles of natural justice, denial of reasonable opportunity, bias, perversity, prejudice, basic error on the part of inquiry officer, and colorable exercise of powers by the disciplinary authority, comma, etc. Full stop. If any such points which had been agitated from the initial authority, inquiry officer onwards, on which the concerned authority have not decided upon, can also be agitated before the appellate authority. Full stop. After having raised all the points, it must also be emphasized that the punishment imposed on the charge-sheeted employee is disproportionate to the charges alleged in the charge sheet. The procedure followed in the hearing before the appellate authority is more or less similar to the hearing afforded by the disciplinary authority following the issuance of the second show cause notice. The hearing before the disciplinary authority is a must in all cases irrespective of quantum of punishment. Appellate The appellate authority gives a hearing only in cases where the dismissal or discharge has been imposed as punishment. The appellate authority is assisted by some official, usually from the disciplinary proceeding cells, whose job is to record the proceedings taking place. Full stop. Apart from the appeal prepared in writing, the defense representative gets an opportunity to argue the case before the appellate authority at length, in elucidating the points covered in the appeal. The arguments before the appellate authority should be a judicious mixture of all relevant facts of the inquiry. Full stop. Special emphasis must be made where disproportionately is glaring. The appellate authority, on receipt of the appeal from the charge-sheeted employee, must approach the appeal judicially. Full stop. Is in a way a reviewing authority proceeding in the judgment over all the aspects of the inquiry, including the conduct of disciplinary authority and also the inquiry officer, and whether there has been a proper application of mind on the part of authorities concerned, and that whether the inquiry stands the test of legality, procedural, propriety, propriety, rationality, and proportionality. Full stop. As pointed out earlier, the appellate authority can either confirm or reduce or set aside the punishment imposed by the disciplinary authority. Full stop. Apart from disposing the appeal within the stipulated period, the appellate authority must give a speaking order. Full stop. The reduction of appeal or reduction of punishment, or even setting aside of the punishment, must be backed by a cogent and sound reasoning. When the appeal is disposed by the appellate authority, the final curtain comes down to the proceedings. Full stop. Certain employees send further appeals to the highest authority in the bank, like a mercy petition, which in most cases evokes a negative response. Such mercy petitions are invariably rejected under the pretext there is no provision for the chairman to interfere in the matter. Before concluding, we would like to give certain cases where heavy punishment imposed by the disciplinary authority had been set aside and the employees acquitted. In one case, an employee was charged of having taken his parents on LFC while his father had an independent business of his own. Full stop. After the inquiry setting were over, the inquiry officer died. Full stop. The disciplinary authority assumed the role of inquiry officer. Full stop. In his findings, an inquiry officer, the employee was found to be guilty of the charge. Full stop. After considering his own part of the disciplinary authority awarded the punishment of dismissal. In the hearing before the appellate authority, it was pointed that the disciplinary authority had not applied his mind to the recorded proceedings. There was ample materials in the testimony of prosecution witness to prove that the business establishment attributed to the employee's father was a traditional business. Full stop. It was not an establishment in the strict sense of the word. The investigating officer had erred grievously in his assessment. Full stop. It could also be established that the investigation report was based upon hearsay and had no connection whatsoever to the ground realities. Full stop. The inquiry officer having died, the disciplinary authority should have appointed another officer to draw up the inquiry report. Virtually, there was no meaning of the disciplinary authority assuming the role of an inquiry officer to draw a report and submit it to himself for consideration and concurring with his own findings. Full stop. Because of the peculiar developments in the case, the appellate authority made his own investigation into the matter and upheld the defense contention. Full stop. The appellate authority set aside the punishment of dismissal and the employee was reinstated with no punishment at all. We re-emphasize that in view of such opportunities being available, the defense representative must approach the appeal in all seriousness and should not look at it lightly.